Manhattan District Attorney Alvin Bragg filed a federal lawsuit in New York against MAGA Republican Jim Jordan, and the GOP-controlled House Judiciary Committee will discuss that case. Donald Trump was deposed for a full day by New York Attorney General Letitia James and her team in connection with the New York AG's civil fraud lawsuit against Donald Trump, the Trump Organization, and Trump's adult children, seeking at least $250 million in damages, and trial is set for October 2nd of 2023. Trial in Dominion's $1.6 billion defamation lawsuit against Fox began in Delaware Superior Court with jury selection and also some fireworks in court the day before, as audio recordings that Fox tried to conceal were uncovered, and they are very damaging to Fox. And Fox has already been sanctioned by the judge before trial even started, with Rupert Murdoch expected to testify very soon. The federal judge in E. Jean Carroll's civil rape and defamation trial denied Donald Trump's request to delay trial, which is set to start on April 25th. And special counsel Jack Smith is following the money with Trump's various political action groups that raised hundreds of millions of dollars peddling knowingly false claims of election fraud and funneling that money to further obstruct justice and undermine democracy, are falling right under Jack's microscope. We'll discuss this and more on this episode of Legal AF. I'm Ben Meiselas, joined by Michael Popok. Popok, action-packed week of legal cases and developments.
It's time for the Popok Porter Board. We've got Trump arraignment on April the 4th. We've got Trump New York Attorney General deposition on the 14th of April, the Dominion Fox trial on the 17th of April, and then we've got the Trump civil rape trial on the 25th of April, and Fani Willis and Jack Smith moving towards May, with, I'm assuming, will be their indictment and charging decisions.
So let's just get right into it because there's so much to discuss today. Let's start with the Manhattan District Attorney Alvin Bragg's federal lawsuit against MAGA Republican Jim Jordan and the GOP-controlled House Judiciary Committee. This case was brought in the Southern District of New York in federal court. The relief it's seeking is injunctive relief to stop Jim Jordan and the MAGA Republicans from further unlawfully interfering with the Manhattan District Attorney's criminal case. And Jim Jordan and the GOP-controlled House Judiciary Committee have continued to interfere. They've done everything from trying to subpoena Mark Pomerantz, who was a former assistant at the district attorney's office under Cy Vance, who resigned during the Alvin Bragg term. They've subpoenaed Michael Colangelo, one of the new hires by the district attorney's office. They continue to do these stunts, like they're holding this, they call it a field trip or a field visit that they're going to be doing at the Javits Center on Monday, where they're going to hold a hearing where they want to talk about how horrible Manhattan District Attorney is and all about the violent crime in New York, even though crime is down in New York, and even though in these MAGA Republicans in their own jurisdiction, crime is significantly higher there, whereas crime is down in New York. So Popok, tell us if you can about this federal lawsuit that was filed, the relief it's seeking. Also, Mark Pomerantz is named as like a putative defendant as well in this case. So maybe you can just describe the procedural posture and the implications.
Yeah, and something you and I talked about before we even got started. And this is for both our viewers here and listeners here in the States and around the world. We have a lot of viewers who like what we talk about the U.S. jurisprudence system and justice system. The things that were on my board to start, this is State versus federal. This is prosecutors in different states and federal prosecutors in different jurisdictions and divisions. And the way the United States works, they are not coordinated. The Manhattan District Attorney, Alvin Bragg, sitting in Manhattan, has state sovereignty over criminal justice in his jurisdiction for local crime that's independent from what federal prosecutors look at, even across the very street. They're in a whole different system, a whole different thing, and they're not usually coordinated in any way, shape, or form. So Fani Willis's decision in Georgia, Alvin Bragg in New York, federal with Jack Smith, they are all doing their own thing. There's no mass conference call or Zoom call with all the prosecutors across state and federal lines to talk about who's going to go first. The prosecution goes first that's ready to go first, and that was Alvin Bragg on the Stormy Daniels prosecution. Fani Willis may be next out of the chute, although Jack Smith may jump in front of her for one or more of the 3 grand juries that you and I are going to talk about later in the segment. So that it's all about Stormy Daniels, and now Alvin Bragg firing back at Jim Jordan, state versus federal, and sovereignty related to that, and federalism related to that. That's just a matter of who was ready to prosecute, not any type of coordination. If you and I were picking which one would go first, it may not have been Stormy Daniels, but it doesn't matter. Prosecutions are ready when they're ready, and they jump out of the box and get out of the chute when they're ready. Here we've got, as everyone now knows, it's you'd have to be living under a rock and be Rip Van Winkle not to know that Trump got indicted for 34 felony counts by a state prosecutor in Alvin Bragg, Manhattan DA. Jim Jordan doing the bidding, along with the MAGA right-wing Republicans in Congress, now we're federal side, has decided to become some sort of super grand jury and look at, crime, local crime at the state level, I guess across the country, but we'll start with Donald Trump's prosecution in state court by a state prosecutor. There is no doubt in anyone's mind, constitutionally, there is no power of oversight in this capacity by Congress over a local prosecutor about what effectively is local crime. Say what you want about Donald Trump, but that's just a crime he committed in false book entries and trying to interfere with an election or gin up results in an election as a result. Jim Jordan has decided, because you have to have a jurisdictional hook if you're Congress before you can do quote unquote oversight. You've got to have some sort of mandate that's provided to you. His mandate, he claims that Alvin Bragg's office used $5,000 out of a multi-million-dollar budget stretching into the hundreds of millions of dollars. $5,000 from a federal forfeiture process or program that gets spread among local prosecutors all around the country. They either use it or they don't use it for, they buy, maybe it supports an intern being hired. Maybe it's used to pay for pencils and paper. But, this is a very small amount of money. But apparently somehow within one of the investigations, not even the Stormy Daniels one, back when Cy Vance had the case, when he was the prosecutor, they used $5,000. I mean, it's all publicly reported. So that's, they use federal funds. I now get to interfere with the deepest, darkest investigations of a local prosecutor. And this, just to be clear, yes, there is an indictment, but we're not done in New York with Alvin Bragg, his investigators and prosecutors' work. This is a live, ongoing investigation. Alvin Bragg, as we'll talk about later, and as you and Karen just did on an amazing hot take about the interplay and the coordination, if you want to talk about coordination, between the New York Attorney General's office and Alvin Bragg's prosecutor's office to bring down Donald Trump. We'll talk about that later. But that is ongoing. He could still, Alvin Bragg, bring what we call a superseding or amended indictment to bring all new charges, including for the very things that on the civil side Trump's being sued for by Letitia James. So that's the backdrop. So now you've got Super Congress, who's decided to do the political bidding of Donald Trump. Let's drag a let's strike an existing prosecutor, two existing prosecutors, one being Alvin Bragg. They wanted to come talk about the case, and Colangelo, who used to be Department of Justice and is now with Alvin Bragg's office. And they think the weakest link is Mark Pomerantz. Mark Pomerantz, as you said in the opener, had been a special prosecutor. He had been brought in from the private sector. He was a private lawyer, not a career prosecutor, by Cy Vance, Alvin Bragg's predecessor, to focus on Donald Trump for a couple of years. It overlapped with Alvin Bragg. Cy Vance did not make the charging decision before he left office. He let it go to the new prosecutor, and the new prosecutor and Alvin inherited a couple of special prosecutors, Carrie Dunn and Mark Pomerantz. Mark Pomerantz and Carrie Dunn, having spent 2 years doing their life's work going after Trump, didn't like that after 90 days in office, Alvin Bragg wasn't ready to make the prosecution decision. And the buck stops with him. And the people of the city of New York, of Manhattan, voted for Alvin Bragg. They didn't vote for Mark Pomerantz. And so they walked. And then Pomerantz ran across the street to a publisher, and he wrote a book called The People versus Donald Trump, in which he laid out the case against Donald Trump from his time as a prosecutor, crapping on the case, including crapping on the Stormy Daniels case in parts of the memoir, and, taking a pot shot at Alvin Bragg. Well, of course, that got the MAGA right wing all excited, because they're going to now try to use and set up some sort of Pomerantz versus Bragg battle over whether this is politically motivated or not, the prosecution of Donald Trump. So Alvin had no choice but to run now he's a state prosecutor, run into federal court, because they're the ones that have jurisdiction over the Congress and Jim Jordan, to sue for an injunction to stop Mark Pomerantz from testifying pursuant to a subpoena, so quash the subpoena, and to preserve the sanctity and the secrecy around the grand jury process, which would also be invaded by Jim Jordan, putting aside the unprecedented act of a sitting congressman interfering with local prosecution decisions. Now, the judge happens to be, and there's a couple of them on the Southern District, happens to be a Trump-appointed judge in Mary Kay Viscasil. So Viscasil used to be a bankruptcy judge. She was a bankruptcy lawyer. And she kind of did that for about 10 years. And then when Trump was looking around for somebody Republican to elevate in the Southern District in New York, he elevated her. Now, there's been some press about, well, she's already against the case because she denied Alvin's motion for temporary restraining order. At the time he filed the case, right along with it was another piece of paper called an ex parte motion for temporary restraining order, which means, Judge, don't even let the other side have a chance to speak. Just enter an injunction right now, because the clock is ticking, because Jim Jordan wants an April 19th subpoenaed appearance by Mark Pomerantz. We got to hurry, do a temporary restraining order now. And the judge said, no, I'm going to deny that, not the merits of the case. I'm going to deny that. We have plenty of time. Give notice to the other side, Jim Jordan. Get him served with this suit. And let's all brief it and appear in court on the 18th of April, where I'll make a ruling. And the 19th of April would obviously be the date for the testimony. I think even this judge, Ben, I want to get your opinion, quashes this subpoena and finds this is a unprecedented incursion into state sovereignty and federalism versus states' rights at the prosecutor level.
I think you give the Trump-appointed judge too much credit there to do the right thing. I don't think that's what's going to happen. I think the judge is going to allow Mark Pomerantz to testify. However, Mark Pomerantz is going to be able to preserve, I think, existing objections that the district attorney's office can assert. So essentially, Pomerantz really can show up. Will be able to assert the various privileges, so will not be able to really testify to anything meaningful. Things about the grand jury secrecy, things about the deliberative process. That privilege is held similar to the way an attorney-client privilege is held with the client. That privilege of the deliberative process, that privilege belongs with the district attorney's office, and Pomerantz isn't allowed to waive it. That's why Pomerantz is a putative defendant in this case, because while I ultimately believe the injunction against the MAGA Republicans likely won't succeed. The injunctive relief as it relates to Pomerantz, I actually think will succeed. And Pomerantz, I think, though, will be restrained from what he is actually able to testify based upon rules of grand jury secrecy. There's one other issue that has been percolating in the federal courts regarding these types of lawsuits against House of Representative committees. And we saw this in a ruling by a Trump-appointed judge in the federal courts in Washington, D.C., where the judge basically found under the speech and debate clause, you can't sue them in federal court for certain actions that a committee takes. So I actually think both on the fact that there may be a speech and debate clause issue at play, number one, and number two, I think as specious as the hook is here about this federal funding, I think the hook gives the judge enough to basically say, we, the federal courts, are not going to be interfering with congressional hearings, but I think there will be narrowly circumscribed limitations as it relates to Pomerantz. Now, as it relates to Colangelo, as it relates to Bragg, as it relates to all this other stuff, I think that it will be far more difficult to, subpoena there. But Pomerantz, I think because of his conduct as well, and I think it's unfortunate conduct. And as we talk about what's happened with the New York Attorney General's deposition of Donald Trump, where Trump actually sat for the deposition, and now the Manhattan District Attorney's Office has a complete deposition transcript of Donald Trump talking about potential financial crimes. Not only do I think what Pomerantz did was inappropriate, but I think history has now demonstrated it was very short-sighted, because Pomerantz's strategy would have precluded the Manhattan District Attorney's Office from getting that deposition that Donald Trump just sat for. So I take a slightly different view than you, given that it's a Trump-appointed judge. But I think ultimately there's not going to be meaningful testimony derived. And let me make one more final point about Pomerantz here. The final point I want to make about Pomerantz is, while Pomerantz thought the falsification of business records case against Trump for the hush money payments to Stormy Daniels was a weaker case than the financial fraud case, Pomerantz's ultimate proposition is that Donald Trump is a criminal who deserves to go to jail for the rest of his life. So even if you play this out and Pomerantz testifies fully, this is why the MAGA Republicans, we call them on the MeidasTouch network, are professional rake steppers, because you're now going to put in someone as a witness who frankly believes the problem with the Stormy Daniels related case is that it's not strong enough against Donald Trump, whereas the real crimes that he wants to see prosecuted are the crimes still being investigated. So it would be an entire hearing on how big of a criminal Donald Trump is ultimately. Popok, I'll give you the final word on this topic.
Yeah, I don't want to nerd out on it, because maybe the first time in 200 episodes, you and I are on opposite sides of this. This is why I don't think I'm wrong, but we'll find out in a week. First of all, there's going to be an appeal regardless. It's going to go up to the Second Circuit Court of Appeals, which is primarily... Hedging your bets. Okay. No, I'm giving the full rundown. I don't think there's going to be. Also, I think we're missing the point here. This is different than speech and debate, which is federal. This is federal versus state. And this is the power of Congress and the precedent that would be set to allow a member of Congress to interfere at the local level, crossing over sovereignty under a body of law that was developed by Karen's office called the Meiselas decision, having to do with Donald Trump's accountant, and when it's appropriate to obtain information across federal versus state lines, and when it is not under a constitutional. Now, Focusio may not get it right. She's not as big a Trumper as people. Oh, she was appointed by Trump. He was looking around for somebody that was Republican. He found it, which is hard to find in Manhattan, but he did find one. I don't think she was ever. I don't know if she's a Federalist. We'll have to look it up. But in any event, whether she makes the right or wrong decision, it's going to go up on appeal to the Second Circuit. He is not going to be testifying on the 19th of April. And then it's going to have to go back to the Supremes, much like the Meiselas case, to see. Alvin had to do this, because if you don't draw the line in the sand right now and you emboldened the MAGA right wing, the Comers, the Jim Jordans, to say, oh, I can do this. Let me go after every, to use their vocabulary, every woke, Soros-backed Marxist prosecutor, the way Donald Trump has just put up in his social media truths, where he says if he gets reelected, right, I'll fire every U.S. attorney. I'll hire 100 new ones. I'll revamp the FBI. I'll stop them from going after conservatives and Christians using the police powers. This is what I mean. This is his platform for getting back into office. If people weren't scared enough of the image of Donald Trump winning an election, listening to him list his grievances that he's going to execute on if he ever gets elected. And this is why this is why prosecutors like Alvin Bragg have to run to federal court and ultimately hopefully to the U.S. Supreme Court if it doesn't go his way, to stop this in its tracks, because you see what'll happen if we don't.
Yeah, and look, of course, Donald Trump uses all of those, loaded language as a way to try to prop up his fascist intentions. Let's have no doubt about it, what it is that the MAGA Republicans and Donald Trump are trying to create here. They're trying to completely remove law and order in our justice system, and that's why it's just so important that we talk about it here on Legal AF. Speaking about talking about it, apparently Donald Trump talked about it. He talked and talked and talked for a full day deposition by New York Attorney General Letitia James. You will recall that before Letitia James filed the lawsuit seeking at least $250 million in damages against Donald Trump, the Trump Organization, and Donald Trump's adult children, there was what was called a special proceeding. And in the special proceeding, Donald Trump was deposed and he invoked his Fifth Amendment right against self-incrimination over 400 times there. In a civil case, unlike a criminal case, invoking your Fifth Amendment right against self-incrimination constitutes an adverse inference. So in a criminal case where somebody invokes their Fifth Amendment rights and decides not to testify, a prosecutor can say, ladies and gentlemen of the jury, do you see that individual's invoking their Fifth? They must be guilty. In fact, the prosecutor can't even tell the jury that the defendant is invoking their Fifth Amendment right or make any inference or imply anything about it. In a civil case, it's different. And the New York Attorney General's case is a civil fraud case. And the case is about Donald Trump making fraudulent valuations, high and low valuations on his statement of financial conditions to get favorable loan terms, to get favorable issues with his taxes, to not pay taxes, to get favorable deals with insurance companies. And so Donald Trump would just say, hey, I want favorable terms on a loan. My property value is higher. I want to pay less taxes. My property value is lower. That's the basic nature of it. And in this civil case where New York Attorney General Letitia James alleges that there was a decade-long plus scheme. That's as far back as the AG statute allows her to go for this particular case. She alleges that Donald Trump should basically disgorge or return the money that he made by lying on his statement of financial conditions. In that case, a civil case where in addition to monetary damages, she's also seeking injunctive relief to effectively stop Trump and his children and the Trump Organization from doing business in New York. One of the things that she's allowed to say, unlike in a criminal case, is, ladies and gentlemen of the jury, Donald Trump invoked his Fifth Amendment right against self-incrimination. You can now make what's called an adverse inference. You can infer, based on the invocation of the Fifth Amendment right, that Donald Trump, for all of the questions he didn't want to answer, you can infer that the reason he didn't want to answer them is that if he did answer them, he would be admitting to the underlying liability that is ultimately at issue in each of the questions being asked. In other words, Donald Trump would lose the case if he invoked his Fifth Amendment right against self-incrimination. And what's the most important thing to Donald Trump? The most important thing in his life is his money. So he said, you know what, I'm going to have to testify at this deposition, because if I don't, I'm going to automatically lose the case. And so he did not invoke his Fifth Amendment rights at this deposition. And he posted on his social media about what he says took place at the deposition. And perhaps he should have invoked his Fifth Amendment right against self-incrimination, because his post was not just further establishing liability, but like further establishing criminal liability as well. So Manhattan District Attorney Alvin Bragg was certainly very, very, very interested in this post. I want to dissect this post with you and what took place at this deposition, Michael Popok, right after this quick break.
This is Michael Popok from Legal AF. If you're like me, you understand the pains of choosing what to wear. Let's face it. Most clothes are uncomfortable, or too tight, or are never actually the size you really are. Not to mention the annoyance of trying to put a good outfit together. And when you do have a good fit, you can only wear it for a few hours before you have an important meeting or dinner, and then you got to change all over again. Everyone wants to dress the best and look good at all times because, frankly, it's a confidence booster. So here's the deal. Men's closets were due for a radical reinvention, and Rhone stepped up to the challenge. Rhone's commuter collection is the most comfortable, breathable, and flexible set of products known to man. And here's why. Rhone helps you get ready for any occasion with the commuter collection, which offers the world's most comfortable pants, dress shirts, 1/4 zips, and polos. You never have to worry about what to wear when you have the Rhone commuter collection. Rhone's comfortable 4-way stretch fabric provides breathability and flexibility that leaves you free to enjoy whatever life throws your way, from your commute to work to your 18 holes of golf. It's time to feel confident without the hassle. With Rhone's wrinkle release technology, wrinkles disappear as you stretch and wear the products. It's that easy. And with its Gold Fusion anti-odor technology, you'll be smelling fresh and clean all day long. And on top of that, Rhone is 100% machine washable, so you can ditch the dry cleaner altogether. I absolutely love Rhone. As you can see, this has truly become my go-to commuter fit and on the Legal AF podcast recordings. We're on the move a lot, whether it's jumping from meeting to meeting or catching a flight or an important dinner. The Rhone commuter collection has never let me down. The versatility and comfort of the collection is undefeated. Even after I wear it all day, I still feel super fresh because of that Gold Fusion anti-odor technology. The commuter collection can get you through any workday and straight into whatever comes next. Head to Rhone.com/legalaf and use promo code LegalAF to save 20% on your entire order. That's 20% on your entire order when you head to RHONE/legalAF, promo code LegalAF. Find your corner office.
Welcome back to Legal AF. Right before we took a break, I showed this post that Donald Trump made about his deposition. Here's what he says in the post. He goes, "An interesting day spent with the Attorney General and her representatives. I strongly made my quote points. They are irrefutable, and it is a case that should not go forward. My company and overall value is actually far stronger and higher than shown in the so-called financial statement. The honorable thing to do would be drop it and spend all of this time, money, and energy on fighting violent crime in New York. It would make a big difference and show real strength and courage by the AG." So in addition to just the delusional aspect of this, the malignant narcissism that he thinks he can basically just post and say, "Hey, New York Attorney General District James, can you please drop it?" Your statement of financial conditions are supposed to be accurate. They're not so-called financial statements. They are your statement of financial conditions that you submitted to third parties like taxing authorities and lenders and insurers to get terms. And here he is, Popok, in this very statement, admitting that he did not provide accurate financial statements. By his own terms, he's saying that he thinks that the statements should have been even higher than they were. And he doesn't understand the central issue of the case is that he's providing false. I mean, maybe he does and his ego can't help it, that he has to say it's actually bigger and better, but that's the crime that he's basically admitting to here. So what happened at this deposition? And do you agree with me that this post is, further digs the hole deeper for him?
He also, let's start with the Post. He also doesn't understand the fundamental difference between a Manhattan district attorney and prosecutor and a New York attorney general. New York attorney generals don't fight crime. They have a very small remit when it comes to certain types of crime, not at issue here. The crime fighters are the Manhattan DA that's already prosecuted him on 34 counts and got a conviction against his other companies on 17 counts of criminal tax fraud. So that's the crime. So he doesn't understand how like government works, which we've heard before. We've always heard. He never understood how the three branches of government works. Like they had to give, insiders would say when he was president, they'd have to give him like Schoolhouse Rock tutorials on how like a bill gets made into a law or how government works. So he still doesn't get how government works. As to his admission, his Freudian slip, yes, he has always been quite clear, including under oath in other cases, that the value of his brand, the value of his balance sheet is whatever he thinks it is when he wakes up in the morning. He's literally said that in prior cases. He said, well, what do you think the company's worth? It's whatever I think it is on that day. If I'm having a good day, sun's shining, and I like my cup of coffee, then it's $1.2 billion. If I'm having a rough day, it's less. Because he thinks brand means hard physical assets on his balance sheet, which are supposed to be capable of calculation and appraised value and not conjured up out of the transom of your mind. Whenever you're going for a loan, you inflate them and deflate them, as you said, if you're trying to write off or pay less on your taxes. And the case, just to remind everybody, because sometimes we talk in shorthand on this show because we've been doing this so long and we're very mindful that there's also new people here that are joining us for the first time. The case is about it's about loan valuation and deflation on 23 properties that Donald Trump owns or owned, including Mar-a-Lago that you've heard so much about, Trump Tower where he lives on Fifth Avenue, and a property that he's now sold that used to be the Trump Hotel, the old post office building in Washington, D.C. That 23, and the total amount that the Attorney General in her investigation that preceded the filing of the civil suit claims it was improperly attributed to Donald Trump and for which he got value in his pocket that should be disgorged or taken from him or clawed back in her lawsuit is $500 million in value, of which she's seeking $250 million at least in disgorgement. He's not the only defendant. Trump Organization is a defendant in the case. Ivanka, Don Jr., Eric. And it's interesting because they didn't all coordinate how they were going to give deposition testimony, sworn testimony to the NYAG at all. Donald Trump, as you said, Ben, gave 500 or so Fifth Amendment assertions the first time he gave his deposition. Eric, he gave 400. Eric gave 500. He didn't answer a darn thing. But Don Jr. and Ivanka apparently did testify and did not assert the Fifth Amendment privilege. So you got sort of a weird thing going on there. Donald Trump, as you noted so eloquently with Karen in your hot take, he is damned if he does or damned if he doesn't now. Because of the way the civil case with New York Attorney General Letitia James and Alvin Bragg's office, who this one I can say with certainty is coordinated because they have had attorneys in each office be deputized by the other, and staff has worked with each other from the very beginning for the civil case and the criminal case to work hand in glove and share information, which they have been doing from the start. It's been publicly reported. Everybody knows this. That Alvin Bragg let, if you will, in the coordination, Letitia take the lead because she's got more powers of economic sanctions, of death penalty for the corporation and for its corporate officers from a corporate standpoint, not allowing them to be officers anymore of New York corporations, to put the corporation out of business and stop its ability to get lending and money. That is in the hands of the New York Attorney General and her powers under what we call the Executive Law 63-12. Very strong, robust powers that the criminal side doesn't have. Criminal side puts people in jail. Maybe there's a little bit of a fine, but it's putting people in jail and taking away their liberty. That is the focus of criminal justice. Civil and a New York Attorney General is so much scarier to Donald Trump because it could tear apart his house of cards finances and maybe not put him in jail, but might as well, let him go into old age broken and busted. So that's the coordination between the two. And where the Fifth Amendment testimony comes in is at that very intersection, because he was so worried in August when he gave the original deposition, or whenever it was, 6-7 months ago, that he said, oh, I got this other thing, got the shark in the water with Alvin Bragg and all the other cases. I got to put up my fifth, even if it means losing the case. Now, and they've been trying to find out, we talked about this on prior podcasts, Alina Habba subpoenaing banks and other parties, trying to figure out what other criminal investigation is out there. Those were all quashed by judges. So they were worried. And now Alvin, having come out of the box with the tax prosecutions, now the Stormy Daniels with more to come. Right? That's a comma. That's not a period at the end of Stormy Daniels' prosecution. He can still go back now and pick up criminally the same exact subject matter that the civil case is being done. There's no double jeopardy when you're talking civil versus criminal. And he's now worried about that, but he wants to win the case that's going to trial in October. So it's basically shooting himself in the head. So he went in and testified for 8 hours, bragging apparently all along the way. Letitia James didn't take the deposition, although she appeared at it and read a statement on the record. We don't know what the statement was yet. We will when we start seeing the transcript if that gets filed. But one of her line deputy attorney generals or assistant attorney generals took the deposition. Chris Keiss, who we haven't heard a lot about lately, he was the guy that took the $3 million retainer from Donald Trump, and Alina Habba were apparently in the room. And where he just bragged about how much money he's had and how he's got a credible $1 billion business. But he had to answer some hard questions. Why did you say that your apartment in Trump Tower was 5 times the size that it really was? Why didn't you use an independent appraisal? Why did Alan Weisselberg say this to this insurance company, Zurich? And why did you deflate the value of something in these 23 properties? There was no way they covered everything in 7 hours. The press is making a big deal out of, oh my God, he was there for almost 7.5 hours. Yeah, but 23 properties and hundreds of examples of fraud can't be covered in 7 hours. I assume this is it. Do you know why, Ben, the judge allowed another deposition? Is this because Trump said, I'll waive my fifth and start answering questions? Like, what was the genesis for this deposition?
It hasn't been reported, but reading between the lines, what seems to have occurred is that Trump's team conveyed to New York Attorney General Letitia James' team that he was actually willing to sit for a deposition, right, because he did not want the special proceeding deposition where he invoked the fifth to be his last word, because he didn't want the adverse inference. So I'm sure Christopher Keiss or Habba, but it was probably Keiss, reached out to New York Attorney General Letitia James, said he'll sit for a deposition, and New York Attorney General Letitia James was like, yep, absolutely. We will take that. We will take that deposition. We will call your bluff. He wants to sit, we'll take it.
And Trump has had, on his end, he's had 7 or 8 months to digest the hundreds of thousands of pages of data and documents, as you like to say on the podcast, most of which are his own, that they obtained from tax preparers and accountants and banks and from the Trump organization themselves to get ready for this. But I don't think you get Donald Trump ready for a deposition. I've prepared people at this level. I'm sure you have too. And with binders of material to get them ready for the deposition. Does anybody really think, with all the other things on my whiteboard today, that Donald Trump sat and allowed Alina Habba and Chris Keiss to properly prepare him for a 7.5 hour deposition with the Attorney General, showing him key documents and shaping responses? Does anybody believe that? If he didn't wing this by the seat of his pants, I'd be shocked, because all he did, according to the Truth Socials, is just do the same talking points he always does about, the value is whatever I think it is, and the so-called financial statements, and like no. Do you understand that there is actual documentation that shows that you committed fraud in the state of New York by your companies? And so while they came out whistling in the graveyard about, oh, we did great, it just, Alina Habba, it just showed that he's the successful billionaire owner that he usually is. 7.5 hours, whatever they decided to cover it, I'm sure they had prioritized in their outline for the New York Attorney General what they were going to cover, knowing that eventually that 7.5 hours was going to go by like that. But we'll know, because now it's interesting. He wasn't able, I don't think, to totally redo the 400 questions that he was asked. Like, I don't think they went through the 400 questions from before and said, you want to change your answer now? So I think this is going to be like a hybrid, a mixed thing where there's still going to be areas where he took the fifth, and there's going to be areas where he has recanted and come up with a new statement. And we're going to have to see how that plays out in front of a trial, in front of a jury.
Yeah, and we'll have access to that deposition the same way that we got access to the prior deposition. I mean, it is a public proceeding. At some point, it will be released. And of course, we'll have it here on the MeidasTouch Network. One final point, everybody can go and watch the hot take I did with our other co-host, Karen Friedman-Agnifilo, about the way that Alvin Bragg really did this like a chess master and how Mark Pomerantz was short-sighted. But if you think about what Pomerantz was advocating for, where he wanted within the first 90 days for Alvin Bragg to bring the indictment before a grand jury and have the grand jury vote on the indictment many months ago, there would never have been this deposition of Donald Trump, and the Manhattan District Attorney's Office would never have had access to this treasure trove of evidence right now. Not only that, but if a criminal case was filed essentially on the same topics that are where, if the criminal case was filed on the same topics of where New York Attorney General Letitia James' civil cases, and they were both focused on the financial fraud, what Trump's lawyers in the New York Attorney General Letitia James case would have done is filed a motion to stay that case or stop that case until the criminal case was completed. And even though Justice Arthur Engoron has said, come hell or high waters, this case is going to trial, I could pretty much guarantee you that in that case, Engoron would have his hands tied and would have to stay the civil case. So not only would Pomerantz's case have led to Donald Trump not giving that deposition in the first place and the Manhattan District Attorney not getting this treasure trove of evidence from the deposition, it actually would have derailed and significantly delayed for many years New York Attorney General Letitia James' case. And so at the end of the day, I think Alvin Bragg's strategy of being very surgical in which cases he's bringing and has brought has proven to be the right strategy here. Speaking about the right strategy or the wrong strategy, it's never the right strategy in the days leading to trial when it is uncovered that you have been suppressing critical evidence in the case, and it's never the right strategy to be lying to your trial judge who's about to preside over your trial. And that's precisely what Fox has done in Dominion's $1.6 billion defamation case. That jury selection is now underway, and this case is in Delaware Superior Court. The judge presiding it over that case is Judge Eric Davis. We can talk a little bit about the jury selection process, but I think what's even more interesting is the fireworks that took place the day before jury selection last week, where Abby Grossberg, a former executive at Fox, she was in her role was like she was like one of the executive producers who was in charge of booking first for Maria Bartiromo, and then on the Tucker Show, she's filed a sexual harassment and retaliation case against Fox. But one of the allegations that she's made in this lawsuit is that in connection with her deposition, when she was deposed, when she was still working at Fox, she says that the Fox lawyers threatened and harassed her and intimidated her and basically told her to lie and say you don't recall things that she can recall. Doesn't that sound familiar? Kind of sounds like what Trump's lawyers were telling January 6th committee witnesses. And by the way, when we talk about Jack Smith a little bit later in the episode, Jack Smith's focused on that exact same type of conduct of how Donald Trump's lawyers may be saying that to critical witnesses there. Anyway, back to Dominion's defamation case. One of the other things that Abby Grossberg says is, you know what? Fox wants to go there. Fox is trying to throw me under the bus. Guess what? When I was subpoenaed for my deposition, when I was still working at Fox, they asked me to produce evidence that was in my custody and control. And guess what I had? I had all of these audio recordings of pre-interviews before Trump administration officials would show up on these interviews with Maria Bartiromo and other shows. And in these pre-interviews that were all recorded, the Trump administration people, whether it was Giuliani or other top campaign people, would say, "Hey, can we go on off the record? We don't really have any evidence about this whatsoever. We don't know any of this. But hey, can you just promote January 6th? Can you like promote that day? There's not enough attention being there. Like, we don't really have any of this information." And rather than Maria Bartiromo and Fox saying, "You know what? Let's not put that on the air because we know they're lying," what would they do? They then put the guest on, and the guest would literally lie about the exact thing in the pre-interview that they were telling the Fox host, like Maria Bartiromo. They had no evidence. So clearly, Popok, in this defamation case where Dominion is alleging that Fox had knowingly and maliciously and or recklessly, that's the standard that you have to show because Dominion's a public figure, that Fox acted with actual malice. Dominion's alleging that they knew and they platformed it anyway. These audio recordings that Fox did not turn over in discovery seem to show that. So Fox was sanctioned. That happens the day before jury selection. And now we're in the thick of it in this case. Tell us about that, Popok, and what else we should expect from this trial.
Yeah, so the trial is in full march now. 12 jurors are being picked in Delaware Superior Court, 12 alternates. They didn't finish. They started on Thursday. They're going to finish on Monday, and I think opening statements for both sides are going to be Monday afternoon. To answer a few nagging questions, no, it's not going to be televised, but the Judge Eric Davis, has given a tremendous amount of media access. There's 200 seats in the courtroom in Wilmington, Delaware. Some of them are going to be occupied by the media. There's an overflow courtroom next to the main courtroom where the proceeding is happening that's filled with media. The media is allowed to have their laptops. They are not allowed to actually record either the actual proceedings with a camera nor the audio, although there is an audio link that people like the MeidasTouch and Legal AFers in our show will be able to phone into every day if you want to sit for 7.5 hours and listen to the trial each day. Assuming we don't overload and blow out the connection, there is going to be audio. But the media has been told by the judge, because he denied their request, they are not allowed to record the audio. So this is a little bit of a gift for Fox, because can you imagine, with the parade of witnesses I'm going to talk about next, being put on the stand on a televised trial? And I'll tell you one media outlet that's not really covering this well, and I looked them up today, is Fox is not covering their own $1.6 billion defamation case. The cast of witnesses that we can expect to be brought in are legion. I mean, wait till you hear this list. Rupert Murdoch is going to testify. Lachlan Murdoch. This is Kendall versus Logan, Succession style, writ large in the courtroom. The news CEO, Suzanne Scott, Tucker, Hannity, Ingraham, Bartiromo, and Dobbs are all going to be testifying over the course of a 6-week or so trial. And then, when they testify, right next to their heads on a giant screen for the jury to see is the cross-examination materials that are going to be used, what we call demonstrative evidence, which is going to be things like text messages, internal emails, internal audio, like you, Ben, mentioned before, and then play it, or have the witness testify and then play it as to why they were lying either in the courtroom under oath, or they were lying in the text or the email. Where were you telling the truth, Tucker? Which one was it? You're either lying in one or lying in the other, and lying or all three, about their understanding that there was no truth to anything that was being said about Dominion. Now, let's back up for a minute. That's sort of how the trial plays out over the next 6 weeks in front of these 12 jurors. They are not anonymous jurors. We will get some information from them, maybe not names, but at least their backgrounds and how many women and how many men, that kind of thing. We'll know that probably from reporting in the courtroom on Monday. Now, just to remind everybody or who's new to the show, there are 3 main elements for defamation. by Dominion voting machines, who says they were lied about on the air with knowledge that it was untrue, and they suffered damage as a result. That is defamation. The three elements are falsity, things were false that were said about them; publication, which is that those statements were made to a third party, either in writing or orally; and third, that they've been damaged as a result. So out of those three elements, 2 out of the 3 have already been established in favor of Dominion by the judge before they even stepped into the courtroom. So if you're in the batter's box as Fox, you've already got 2 strikes against you. The jury will be instructed by the judge at the appropriate time. Maybe even in the very beginning, there'll be a written statement about what this case is about, ladies and gentlemen of the jury, from the judge in the black robe. And he will say, this is a case of defamation involving Dominion Voting Systems, a Denver-based company, against Fox News and Fox Corporation, and these other individuals, some of which, Bartiromo and Dobbs. And before you even came into this courtroom, ladies and gentlemen of the jury, I made some rulings. And here are my rulings. You are to assume that everything that was said about Dominion by Fox News and its on-air personnel was false. Judge said in an order, it was crystal clear that it was false. He'll say to the jury, it was false. So that element of the 3 elements you have to decide is off the board. You are to assume it's true. You're to assume it's false. The second element is publication. And I've already found, ladies and gentlemen of the jury, there's been publication. So you don't have to worry about that element. You got one element left to decide. And then one defense to decide. The one element left is damage. How have they been damaged? Obviously, they've been damaged. And what is the amount of that damage? That's where you have a battle of experts about, is it a $1.6 billion defamation case? Is it a smaller amount of money? Or does the jury just pick its own number, which is usually what happens? And then lastly, the judge will say, you have one other issue to decide. That's a defense. The defense is whether this news organization, this media company, gets the benefit of a protection under the First Amendment because there's a showing or no showing of actual malice, meaning they knew it was false what they were saying, or they did it with reckless disregard of whether it was true or false. If you find, for instance, that they didn't know, or they exercised proper care to determine whether it was true or false, then you're to find for Fox. If you find that they knew or should have known, you're to find for Dominion, and you'll hear evidence. And that's what he's going to instruct them at the very beginning. So already, before we get to the sanctions that the judge already laid out on Fox, this is what, stepping into the box, Fox has to deal with in terms of, it's not that the liability has already been established to get them, but it's pretty darn close, and the jury gets to go to damage. Now, on the remaining issue that's really interesting, for me about all of this is the sanction. So what happened is Fox has been late producing documents and data and recordings all along the way, including 2 or 3 days ago, some of which is coming from disclosures in the lawsuit that you just described from the former producer who was fired, who's going to be a witness, has already been declared to be a witness in the case we're discussing right now. She will be brought in for this particular case by Dominion. One of it was this recording that you're talking about, including a recording in which the Sidney Powell, who's the grand master schemer about this conspiracy that Dominion is claimed to have been involved with the Venezuelan government and Hugo Chavez and phony software and bribes to Georgia officials and the like, all false. That part of her foundation for making that statement, Powell, to Fox News was a woman who claimed to have time traveling superpowers. I'm not making this up. And using her time traveling abilities, she found out this information. And Bartiromo was on the phone during this. Now, any legitimate news organization would say, I'm sorry, did you just say that the basis for your statement about this is a time traveling superpower person? And that is, at its very essence, actual malice, if that is all true. So that evidence came in really, really late. The second piece of evidence that came in really late that pissed off the judge is the relationship between Rupert Murdoch and not the parent company, Fox Corp, but Fox News, because they always took the position at Fox that Rupert's just like the titular head. He's really not involved with day-to-day news operations. His emails are interesting, but they don't really influence policy over at Fox News, until they discovered that there is a corporate filing that says that Rupert is the operational chairman of Fox News. So the Dominion people jumped up and down in front of the judge 2 days ago and said, Judge, this changes the whole complexion of the case. We did all our discovery based on a representation by them in this courtroom that Rupert Murdoch had no role over at Fox News. So we've been trying the Fox Corporation case separate from the Fox News case, but look at the interaction between the two and his control over it. And the judge says, yeah, I'm really annoyed about this. Judge said, I was misrepresented to. He didn't say lied. I was misrepresented to by lawyers for Fox in this courtroom. And now I got to do something about it. So he did two things. He said, I'm going to sanction Fox as follows. There's going to be a new series of depositions that Dominion thinks are necessary to get to the bottom of the Rupert Murdoch involvement on the news side. And Fox is going to pay for all of that and the attorney time and everything related to that. That's one. Two, I'm thinking about appointing a special master, usually a retired judge or magistrate, to go look at all of the emails and correspondence among the lawyers and the client, Fox, about the discovery process, the collection of documents and data. And then I want a full report back to me. So everybody hold on to your papers and don't destroy anything, because I want to look at it. And then I'll come up with an appropriate sanction. Now, some people might be thinking, well, the trial started already, or it's going to start on Monday. Who cares about sanctions? Well, first of all, you take time out from trials to go do depositions. It happens all the time. The judge says, hey, everybody, ladies and gentlemen, the jury, we're not going to meet on Wednesday. The lawyers and the judges have something we got to do. And so they go do a deposition. But the real sanction here, Ben, is if he finds out that he was lied to as a judge, one penalty that he could assert is effectively a death penalty. He could sanction Fox by striking their pleadings, striking their defenses, and finding liability, basically a default judgment against Fox. And that could happen during the course of the trial. So they're not out of the woods, because while the trial is going on in the courtroom we're all following, we also got to keep an eye on what's going on before court starts and after court starts and during lunch breaks, when there are hearings on these issues with the jury not present, where the judge will have to make a decision about what is the appropriate sanction against Fox. If he goes all the way to death penalty, the jury will come back one day and be told, thank you for your service. We don't need you any longer. I've made a decision on liability. Let's get to damages only. That could happen.
Well, we will be following that very closely here with hot takes probably every day as we learn what's going on in those proceedings. We still have a lot to discuss on this episode of Legal AF. E. Jean Carroll's civil rape and defamation trial set to start April 25th. Donald Trump tried to delay it. Donald Trump was not successful in trying to delay it. Special counsel Jack Smith is focusing on following the money and where Donald Trump is putting all of that money he raised, grifting and lying to followers that it was going to an election defense fund, and there was no election defense fund that even existed. And we should also touch upon the fact that Donald Trump did in fact file a frivolous $500 million lawsuit against Michael Cohen in the Southern District of Florida. And there was an entire section, Popok, called podcasts that referenced the MeidasTouch podcast network. We'll talk about that and more. Let's just take a quick break.
And now let's take a quick break to talk about our next partner, Lomi. Now, I've never been able to compost before. It was always too complicated, too much work, and frankly, I don't think I even knew exactly if I was doing it right. Then I got a Lomi. Lomi allows me to turn my food scraps into dirt with just the push of a button. Lomi is a countertop electric composter that turns scraps to dirt in under 4 hours. There's no smell when it runs, and it's really quiet. Thanks to Lomi, I have way less garbage each week. My family, we're down from 3 bags per week to just 1. And here's something pretty cool. My wife, she recently started gardening, and we've been able to use the dirt that Lomi produces to help fill the garden. And since I got my Lomi, I throw out way less garbage. That means it's not going to landfills and producing methane. Instead, I turn my waste into nutrient-rich dirt that I can feed to my plants. I feel so great knowing that I'm composting and creating soil instead of waste. And I have basically a limitless supply of dirt from my garden. The other week I had my in-laws over for dinner, and the food cleanup process was such a breeze. Plus, they all think I'm super eco-conscious now. If you want to start making a positive environmental impact or just make cleanup after dinner that much easier, Lomi is perfect for you. Head to lomi.com/legalaf and use the promo code legalaf to get $50 off your Lomi. That's $50 off when you head to lomi.com/legalaf and use promo code legalaf at checkout. Food waste is gross. Let Lomi save you a cold trip out to the garbage can.
This is Michael Popok, Legal AF. Cold turkey may be great on sandwiches, but there's a better way to break your bad habits. We're not talking about some weird mind voodoo from your wacky neighbor or some sketchy message board. We're talking about our sponsor, Fume. And they look at the problem in a different way. Not everything in a bad habit is wrong. So instead of a drastic, uncomfortable change, why not just remove the bad from your habit? Fume is an innovative, award-nominated device that does just that. Instead of electronics, Fume is completely natural. Instead of vapor, Fume uses flavored air. And instead of harmful chemicals, Fume uses all natural, delicious flavors. You get it. Instead of bad, Fume is good. It's a habit you're free to enjoy and makes replacing your bad habit easy. Your Fume comes with an adjustable airflow dial and is designed with movable parts and magnets for fidgeting, giving your fingers a lot to do, which helps with de-stressing and managing anxiety while breaking your habit. The first time I used Fume, I was shocked at how flavorful and fresh it tasted. It's easy to hold and perfectly balanced. Quite honestly, extremely fun to fidget with. The real wood material and sleek design definitely classes it up, and I feel pretty darn cool holding it. Stopping is something we all put off because it's hard, but switching to Fume is easy, enjoyable, and even fun. Fume has served over 100,000 customers and has thousands of success stories, and there's no reason that can't be you. Join Fume in accelerating humanity's breakup from destructive habits by picking up the Journey Pack today. Head to tryfume.com and use code LEGALAF to save 10% off when you get the Journey Pack today. That's tryfum.com. Use code LEGALAF to save 10% off the Journey Pack today.
Welcome back to Legal AF. I just want to touch shortly, just for a brief moment, on the Michael Cohen lawsuit, only because Trump references us there. I mean, it's a completely frivolous lawsuit, I think, against Michael Cohen there. He's basically suing Cohen for breach of confidentiality, breach of fiduciary duties. He's saying that Cohen, who, by the way, Trump has accused of lying, I guess in this lawsuit, he's now accusing Cohen not of lying, of revealing the confidences as part of the attorney-client relationship, while at the same time, Donald Trump talks one about all of them publicly, which would be a waiver of attorney-client privilege to begin with. The fact that you can't claim confidentiality over crimes, right? You can't be in a criminal conspiracy with your lawyer, and then when the lawyer speaks to legal authorities, go, you violated my confidentiality for speaking with the criminal authorities. You can't do, so Donald Trump's lawsuit is completely frivolous. And then there's this whole section there about podcasts and talks about how Michael Cohen's podcasts on the MeidasTouch network made Donald Trump very sad and very upset. So I know we're having a big influence there. One point I'll make quickly, but I don't want to belabor the Michael Cohen lawsuit because, frankly, I think it's a completely frivolous lawsuit.
I want to talk about the judge. I want to talk about the judge, though.
I'll let you talk about the judge because I want to move on to the E.G. and Carroll. So I'll let you hit it. Popok?
Yeah, I practice in Miami. I know Judge Gales. Judge Gales is an amazing judge. He started on the circuit court, state court, where this is a constant theme on the show today, state versus federal, and the different systems in the United States. Got elevated by Obama to the federal bench in Miami. He's been on there for about 10 years. The first openly gay black man at the time of confirmation to be on the federal bench. And it is exactly the opposite prototype of a judge that Trump, in his forum and judge shopping, was trying to do by filing in Miami. We talked a lot in prior podcasts about Trump being deathly afraid of Don Middlebrooks, the judge up in West Palm Beach that sanctioned him and Alina Habba over $1 million and has found basically all of his filings to be without merit and fraudulent. And so here we have another false bad faith filing by Donald Trump in yet another federal court. And rather than filing it across the street in Palm Beach County where he lives, at Mar-a-Lago, he electronically filed it. I used to say he drove down there because that's how he used to file, but he electronically filed it in Miami. Why? Because there's a fair number of conservative Federalist Society federal judges in Miami. If you're going to pick one courthouse in the Southern District to file in, if you're looking for that, then you would try it and spin the wheel and see what happens. What came up instead is Judge Darren Gales. If anybody doesn't understand, this is a proxy for the Trump versus Obama fight that's been going on since he ran for office originally. If he keeps the case going, it's without merit. He may dismiss the case, having now seen who the judge is going to be, because another $1 million fine could be in the offing based on what's been alleged here against Michael. So we wish Michael well. At the end of the day, it's the wrong courthouse, it's the wrong court, and it's a lot of claims that look very stale and potentially barred by the statute of limitations.
And everything Donald Trump says is a confession, right? He always accuses everybody of, you're judge shopping, you're doing this, when it's not judge shopping. It's like just a random assignment of a judge in the correct jurisdiction. Meanwhile, Donald Trump actually does the judge shopping. So it's just yet another example of projection, and yet another example of Donald Trump's tactics: delay in E. Jean Carroll's civil rape and defamation case against Donald Trump, set to go to trial on April 25th. Donald Trump's lawyers filed a motion asking for a cooling off period. They said this was a carnival-like atmosphere that's been created since Donald Trump was criminally arraigned, and so please, can we have a 4-week delay? That's all we need. The judge really wasn't having any of it. Popok, what's going on here? This case is going to trial.
Oh, yeah. This is the second time in a week the judge has denied the 30-day extension. It's obvious. This is the tell if you play poker. They keep asking for 30 days because Donald Trump's not ready. Why is Donald Trump not ready? Because he's been doing a lot lately. He's just got arraigned. He just gave a deposition. New York Attorney General. He's got 3 at least grand juries he's dealing with and appeals and down in D.C.
You know what I was thinking of, Popok?
He's a little busy.
You ever have a friend? I'm so sorry to interrupt. You ever have a friend, who's just like, hey, I'll be there in 5 more minutes, right? Then after 5, right, and after 5 minutes, I need 5 more minutes, right? And then after that, please, just give me 5. That's basically the strategy here.
Yeah. Yeah. And so now there's one piece of reporting that came out that everybody's jumped on in mainstream, but let me just set it straight. As a trial lawyer like Ben, who's been in courtrooms like the one that is the E. Jean Carroll case that's being tried in, this civil rape case, and the defamation related to statements made by Donald Trump after he was president, which we refer to in the business as the Carroll Roman numeral II case, and we'll distinguish it from Carroll 1 in a minute, is going to trial on April 25th. I don't care what Alina Habba and Joe Tacopina and how much high chair, baby formula throwing they're doing. They're going to trial. So they got one little thing that they're decided on the Trump side to they think is a gift, and it's a big nothing, and it's going to be a big nothing in front of the jury. But let me explain it, and let me tie it to a Jack Smith investigation that we're going to do a little bit later on that I think go hand in glove.
Not even a little bit later on. We're almost there. We're almost there.
What I mean is, no, we got 3 more hours of the show. What do you mean, Ben? No. What I mean is that there's a connection between who's paying for the lawyers. Hold on to that topic for a minute. Because at the time I was like, who gives a crap who's paying for the lawyers? But now I see the connection that Trump's trying to make to run interference for what's happening in grand juries. In the E. Jean Carroll case, it came out when they were prepping E. Jean Carroll, the lawyers for E. Jean Carroll, Robbie Kaplan and her law firm. I'll talk about the law firm in a minute, which you do when you're getting ready for an April the 25th trial where your lead witness is your plaintiff. You prepare her. You prepare all the witnesses you're supposed to. So in preparation, in going over her deposition transcript, they came across a line in there where Alina Habba had asked her in deposition, E. Jean Carroll, who's paying your bills for the litigation? And she said it's on contingency, which is true, meaning Robbie Kaplan's firm is going to get a percentage of any recovery, but until then, unless there's a recovery, she doesn't get paid. They said, what about other things or other fees or costs? And there, not every client knows what's going on about funding and this kind of thing. She said, I'm not sure. I'll have to get back to you on that one. I don't know. Okay. And then they went on. And then when Alina Habba, this is again sloppy Alina Habba again. We've seen this in the past where she forgets to do something in the case and the judge has to remind her, well, you had your chance, but you never asked me to do anything about it. She did it again because they sent out discovery requests to E. Carroll and said, give us information about how your fees are being paid by your for this case and anybody else that's helping to support you. And they objected. And they said, objection, attorney-client privilege, relevancy. And Alina Habba didn't do anything about it. She didn't bring it to the judge's attention. She didn't file a motion to try to get that information. She just let the objection lie on the table. Now, in preparing, it turns out that Reid Hoffman, who is the LinkedIn founder and a billionaire because of Microsoft when they bought LinkedIn, and supports democratic and progressive causes, just like Peter Thiel does on the Republican side, like the Koch brothers do, and all of that, and everybody else who's a big funder for Donald Trump. He gives to causes, including to allow people to pay the cost of entering a courtroom to vindicate their rights. That's a public service that he does. It's a public charity. He can spend his money any way that he wants. Put that next to E. Jean Carroll's lawyers, Robbie Kaplan, when she founded her law firm in 2017, around the same time I founded mine in New York. She dedicated her law firm to public interest law. About half of her practice is taking free causes on contingency, including going after Donald Trump a few times and winning. And then the other half of her practice is, she's got corporate Fortune 500 clients that pay her, $1,500 an hour. But she does both. And so as part of that, the law firm hooked up with Reid Hoffman's foundation and got some funding along the way to defray certain costs and fees, not attorney's costs, not attorney's fees, costs and fees that go along with a case. And just as a little tutorial, when you try a case, you got a lot of things you got to lay out of pocket when you're a plaintiff's side contingency lawyer. You've got experts that got to get paid. Experts can't work on contingency. They have to get paid. So let's say the DNA expert, the expert on E. Jean Carroll's economic damages, that could be $200,000 or $300,000 or more worth of expenses. Court reporter costs for all the depositions, that could run $50,000 or $100,000, and so on and so on. You could easily, in a case like this, have $5 million or $10 million worth of invested time at the attorney rate of $1,500 an hour and have $500,000 worth of costs that you're running as a law firm. To defray some of those costs, Robbie Kaplan said, hey, Reid and the foundation, you gave me money for one of my other cases. I got some leftover. Can I use it towards E. Jean Carroll after the case had already been filed? It had already been up and running a year. And they said, sure, you can apply it. So they use it to pay who knows what, copiers, DNA, filing fees, whatever, not to put money in Robbie Kaplan's pocket. That the client didn't know about the intricacies of this whole relationship is a big nothing. And the fact that they're using it to say, aha, Reid is really he's the puppet master. And E. Jean Carroll is being led around by her nose. And this is all about politics and a hoax and a vendetta, just as we always said. And the judge says, okay, that's sort of interesting that she didn't quite know exactly how costs were paid. So do an hour deposition, go off and do it. You get 1 hour on that topic only, and then come back, we'll talk about it. And the question is whether it's going to go in front of the jury, whether she really perjured herself, as Alina Habba likes to say. But let me just draw a line in the sand here. If Takapina and Habba really thought they had E. Jean Carroll dead to rights on a perjury, lying under oath, or anything like that, they would have kept that evidence in their pocket. They would have used it at the trial itself to embarrass her. They would say, well, do you remember when you were deposed? Yes. Do you remember when we asked you the question, were there another funder? And you said, well, at best, she said, I can't really remember. I'll have to get back to you. Oh, but isn't it true that Reid Hoffman's LinkedIn Foundation is paying for a part of your $30,000? And she'll go, okay, maybe that's true. I don't know. You'll have to talk to my lawyer. And the jury's going to be like, why are we here on this? This is not a they're never going to believe, Ben, that this is a proxy battle between Reid Hoffman and Donald Trump. This is a civil rape case that's being tried in front of a jury where the victim is the plaintiff, and that is E. Jean Carroll. That there was some pencils and paper and DNA tester paid for by Reed's Foundation to defray some costs so that the lawyer didn't have to carry it. What does that have to do with the rape charge?
Nothing. It's a big nothing burger. It's going nowhere. They used it because they wanted a delayed trial. Trump's going to trial April 25th on a civil rape and defamation case where E. Jean Carroll is going to be calling other individuals who Donald Trump raped, who will be testifying. E. Jean Carroll will be showing the jury the Donald Trump Access Hollywood tape where Donald Trump brags about sexual assault. That evidence is allowed in. Donald Trump will be testifying as well, where Donald Trump has said in his deposition that E. Jean Carroll's not his type. That's why he would not rape her. And then he said that he thought that E. Jean Carroll was his ex-wife in one of the photographs. So all of that will be going before a jury. So a lot of action there. As with
before you move on. Sorry, good. I didn't mean to interrupt you. Go ahead.
That's all I got.
No, I was going to say before you move on, because I did promise something and I want to wrap it up here. There was an appellate decision that just came out by the D.C. Court of Appeals, not the federal Court of Appeals, the one that sits in the District of Columbia for that territory. They are going to, based on the ruling, the Carroll one case, which is her original filed case that she was defamed while Donald Trump was president, and the question of whether he had immunity or not as the president, because if he did, then that case is over. That case was already stayed by the judge. The judge says, let's just do the case of the civil rape, which will go on, and whether after he was president, she was defamed. That's April 25th. The other case, maybe we get to it, maybe we don't. Let's let the appellate court do its job. The appellate court came back and said, it's a fact-intensive issue, and we're not going to be able to get to the bottom of it here, so go develop facts with a jury. So basically, the new ruling would allow, in theory, a second trial of Donald Trump, regardless of what happens here. But I think if she wins here, the case is about over. And then lastly, and then segue into our Jack Smith segment, now I see what they're trying to do. Because one of the investigations that's now become a little bit more public about Jack Smith is into Donald Trump raising money and using it to pay for lawyers. And how does he pay for lawyers? And what are the representations that he's made? And what do those lawyers do in terms of witnesses that are part of the investigation? This is just a talking point about E. Jean Carroll being supported, or as even Axios said out loud in their headline, that E. Jean Carroll was being bankrolled by Reid Hoffman. That is a lie. That is not. The bankroll comes from, what's the matter?
No, I know you look, Donald Trump is it's a head fake by Donald Trump. And I don't want to belabor the point, and give it more attention than it deserves, because as we go to Jack Smith, Donald Trump has received 16 million. Well, he's paid out $16 million in defense costs and legal fees from his political action arm. Okay. So whatever little bit amount that E. Jean Carroll received, it is a complete ridiculous, it is a ridiculous thing that matters. Boop, zip. Because what the real issue is that is going on is that from November of 2020 to January 6th of 2021, Donald Trump, from just that time period alone, based on 2022 disclosures, we don't even have the 2023 disclosures yet because political action arms don't have to report those for another few months. But Donald Trump raised about $250 million, making false claims about the election. And that is an area that Jack Smith is very, very focused on because, one, Donald Trump, where is this money going even? Well, they've created a number of shell companies and shell corporations that are controlled by kind of Donald Trump loyalists. So money goes there. Then once it goes there, where does the money go after? That's something that Jack Smith is focused on. And then how is this money also being used to potentially try to control witnesses? How is this money being used to have lawyers who would be appointed to maybe try to change the testimony. Popok, what do you think about this?
I was going to do a little board. Look, there's as you just laid out, there are 3 investigations that we are keeping our eye on. The most recent one that looks like it's heating up is going to focus on wire fraud, which is frankly the easiest and most potent tool in a federal prosecutor's arsenal is wire fraud. And the focus on that is every time he grifted and every time he tried to raise money on the backs of a lie about the election and took money from the babies, took money from his followers, each element of that email blast that went out, every email individually is a wire fraud crime. Because we should put up, I think we can put up with Salty, 18 USC 1343. Which is, and people always say, well, what's the wire? Well, we've evolved technology. The wire used to be, telegrams and telegraphs, but now, and radio and phone, that's a wire. But now email is a wire. So it says whoever has devised with the intent a scheme to defraud or obtaining money by false representations by wire, that's email. So every time he grifted by email, that's a wire fraud charge. This is the biggest target on the back of Donald Trump right now because it's the simplest path to prosecution and to conviction is the wire fraud. So they're focusing on the grift. They want to know the money that was raised and what he did with it. You laid out, Ben, $16 million for attorney's fees. They also want to know if he weaponized the use of attorney's fees to put the 20 or so people at Mar-a-Lago and his inner sanctum aides to put them under control to try to influence their testimony by buying their silence or buying their cooperation by giving them attorneys. Cassidy Hutchinson testified to just that very thing in the Jan 6 committee. The Mueller report revealed that even Michael Cohen and Michael Flynn were both improperly influenced by Donald Trump including by helping to pay for lawyers or bringing in lawyers to help them. So now that's a focus, all of that. The question is, the odds makers, like in Vegas, are looking at what you and I have always said were at least 3 grand juries, and now we know there are. Mar-a-Lago, which has to do with national security implications, possibly the Espionage Act and obstruction of justice. And now we have new reporting that Trump may have taken a map with secret, confidential, sensitive intelligence information and showed it to people in the White House, on Air Force One, to donors, and all sorts of other things. They've already gotten testimony from General Miley, the Joint Chiefs of Staff head, on that. So you got the map issue there, which of course Trump's lawyers have already reached out. Oh, worry about the 21-year-old Massachusetts airman that leaked 100 documents. That's on your watch, Biden, with the 1.5 million people that have top secret security clearance, instead of focusing on what Donald Trump did with his map. But the map has become a big focus of the investigation. And then you've got the Jan 6th fake electors, interference, pressure on Mike Pence, Georgia issue. We'll talk about that in a minute. And then the third one is this one, which is the PAC fundraising fraud, scamming the donors, wire fraud, Save America PAC, using the money to corrupt the process, obstruct justice, and witness testimony. If you're a betting person, Mar-a-Lago, according to insiders, is about done in its investigation. All witnesses that relate to Mar-a-Lago, all, and ending with the capstone of Evan Corcoran, are done. So if I were a betting person, Mar-a-Lago is the first out of the chute by Jack Smith's prosecutors with a recommendation to our Attorney General, Merrick Garland, and then a prosecution. The second one, I think, is now the PAC. I think the PAC fundraising fraud has now caught up. It's still a little bit behind Mar-a-Lago because there's still more to do there. And then the third one is the most complicated one. So obviously, not surprisingly, in third position, which is the fake electors interference also. And then you've got the issue about the race between Jack Smith, talk about lack of coordination, the race between Jack Smith and Fani Willis on Georgia interference. Because if that's a part of the federal side, because it was a federal election, and therefore he has jurisdiction, there's going to have to be either some coordination or Fani's going to just say, I'm going first. If she goes first, it'll be a slight problem potentially for Jack Smith's prosecutors, and she won't necessarily have to stand down because there is a distinction between state and federal prosecutors. So you've got all that going on. But I don't want to undersell the how serious the focus that the reporting is now out there, that wire fraud is the one that they're going to try to use against him on the obstruction and the PAC. Because as I was half joking with our producer before the show started, every email, and he does hundreds of thousands of emails through his fundraising, every email is an individual count of wire fraud. They don't group them together like the Tuesday emails. The charges alone, and it is the easiest. It's the one every time you get an indictment in white collar defense, the way you and I do it sometimes. Every time there's a mail or wire fraud charge in there, because it is the easiest one for the prosecution to prove and certainly to indict.
Yeah, look, you look at the email. The email says, donate right now to the Election Defense Fund. They raise hundreds of thousands of dollars per email or millions of dollars per email. You then ask the witness, okay, so did it go to the Election Defense Fund? And then they go, there wasn't an election defense fund. So they're like, oh, so you just said an election defense fund? Yeah, it was just a marketing tool that we used. Okay, so you mean you lied to people and said that there was an election defense fund? Okay, well, where did the money actually go? Well, we used some of that money to go to the E. Jean Carroll defense. Wait a minute. So you use the election defense money to pay for Joe Tacopina and Alina Habba's fees to defend Donald Trump in connection with E. Jean Carroll's civil rape and defamation case against Donald Trump? Yeah, but we could do whatever we want. We have a disclaimer that says we could do whatever we want. Well, let's go back to your email. Your email says it's going to an election defense fund, though. So that's what you told your people, and you knew at the time that's not where it was going, correct? Correct. That's how that actually plays out in real time with that one email. And so Donald Trump's response to Jack Smith's increasingly productive investigation is to call Jack Smith a warthog. So he went from calling Jack Smith a mad dog psycho, and now this morning he called him a warthog. And Donald Trump is having a conversation with himself this morning. He is responding to a like, this is like a real maniac. Like, this is not normal behavior. So he first posts, Biden obstructed with thousands of boxes loaded up with classified documents, many stored in Chinatown, whatever the hell that means.
He's just slurring Chinese Americans, but go ahead.
Exactly. And then he responds to himself and says, true, Biden is guilty of obstruction, 1,850 boxes unchecked, many found in Chinatown, heavy on classified documents. He has been totally uncooperative, won't show docs. I went by the Presidential Records Acts, have right to declassify and did nothing wrong, but was purposefully given by DOJ and Biden, a Trump-hating lunatic prosecutor, Jack Warthog Smith, who is a harasser and abuser, in order to obstruct and interfere with the 2020 presidential election. Public won't stand for unequal treatment. I mean, I could probably spend a very long time explaining why. I mean, it's very easy to do it, but I could go on and on and on with every single lie here. But everybody recognizes that this is a maniac who is just completely unhinged, and each and every day, crashes and crashes even more. This is someone lonely, isolated, actually having conversations with himself.
Yeah, he said
every prosecutor.
He said, right, Donald Trump from 2 days ago. That's a very good point. And then he made his statement. But there's also this. Just one last thing. But there's also this this undercurrent of a continued misogyny and racism in everything he posts. If you are a black prosecutor or attorney general, he uses racist tropes. Calls Letitia James peekaboo, which is a play on a racist name I'm not going to say out loud. He calls all the black career professionals racists, Soros-backed, and all of that. Animals, which dehumanizes them, threatens to brain them with baseball bats. If you are Jack Smith, who's not those things, whose name is Jack Smith, then he's like a warthog, but not a racist. He's not an animal or inhuman. He's not inhuman. He's not the other in that way. It's just another continued. I don't even know what warthog means. I mean, it's just another way for people.
The animal, the warthog, because you know.
But I mean, I know what warthog is. Thanks, Ben. I know what a warthog is. What is the warthog, Ben? No, but why does it apply to Jack? Is his beard, his hair? I mean, I don't really understand. But it's not racist. Right.
He does have an anti-Semitic trope that he does with Jack Smith, though. When he goes, Jack Smith isn't his real name, and he's basically saying that Jack Smith's secretly a Jew who changed his name to Jack Smith. So that's one of the things that Trump does, where he goes, Jack, not his real name, Smith, in other posts as well. So there's that. But this is an individual who the Republican Party is like, you know what? You should have our nuclear codes. You know what? You should be the one who makes decisions over the life and death of my family and friends and neighbors and community and colleagues. Let's give this person more power right there. And look, I think the contrast could not be starker between that way of thinking and real law and order, pro-democracy. And that's why we cover these topics here on the MeidasTouch network and right here on Legal AF. We covered a lot today, Popok, a lot of topics, very important topics. You and I and Karen Friedman-Agnifilo and the whole team here at the MeidasTouch network is going to be very, very busy. But you know what? Busy is good. And there's no one who I'd rather spend this time with than all the Legal AFers out there, and you, Popok, and Karen Friedman-Agnifilo. But all of the Legal AFers, none of this is possible without you. We're so grateful for all of your support. We've got some great announcements coming too about some new initiatives we're going to be building to expand the brand here at Legal AF over the coming weeks. So everybody stay tuned for that. You can check out store.meidastouch.com for the best pro-democracy gear, including official Legal AF merch. That's store.meidastouch.com. If you want to support MeidasTouch Network as well, we're not funded by any outside investors. You can go to patreon.com/MeidasTouch, patreon.com/MeidasTouch. That is one of the main ways we fund this network. One of the other ways we fund it is through our sponsors, so I want to give a special shout out to all of them. We have a link of our sponsors in the description, and they're actually great sponsors, and we do use all of those products. And so, make sure you check that out as well. Hit subscribe on our YouTube channel. For all our YouTube watchers, make sure you subscribe on audio podcast as well. To all our audio podcast listeners, subscribe to the MeidasTouch Network on YouTube as well. I'm Ben Meiselas, joined by Michael Popok. Thank you for watching this weekend's episode of Legal AF, and a shout out to the Meidas Mighty.